of this. This statement I knew. Rajasthan has topped among large states and overall health performance in the second edition of the report. So this is something which tests your memory. Not there is no reason or analysis that you can apply, because it's a factual statement which is provided, and I don't want to discuss much on this. So you go with the key, and the key states, I think B, 1 and 3, that means the statements are incorrect. So the only possible statement is the report ranks states and union territories innovatively on their year-on-year incremental change in health outcomes as well as their overall performance. And why Rajasthan is not there, and the key states, it is part of annual growth, not overall growth. Not overall growth. So coming to the second question, this is where I feel more comfortable. The ideal of justice, social, economic and political has been taken from which of the following? Russian constitution, straight and simple. Because whenever social economic comes, it cannot be with any other constitution other than Russian constitution or communist constitutions. If it is liberty, then you can always fall back on capitalist constitutions like American constitution or British constitution. But when it focuses on social and economic, invariably it has to be a communist government. So it has to be a Russian government, because capitalism believes in liberty, communism believes in equality. Communism identified with equality, capitalism identified with liberty. So wherever you come across social and economic equality, it has to be something to do with the communist countries. So Russian Revolution is the only choice. Because what did French Revolution brought in? What did French Revolution brought? French Revolution, liberty, equality and fraternity. The modern values of society, modern values of governance, liberty, equality and fraternity are advanced by French Revolution. And American War of Independence brought you with Bill of Rights, fundamental rights, and the separation of powers with checks and balances inbuilt. And the Russian Revolution, it provided you with the fundamental duties as well as the concept of justice, socio-economic and political. And Industrial Revolution, it only advanced the enhanced wealth creation. Enhanced wealth creation, nothing to do with any particular value. So Industrial Revolution, if you want to identify with a value, it is laissez-faire economy. It is a laissez-faire economy. Consider the following statements. Every naturalized citizen must take a oath of allegiance to the Constitution of India. What is naturalized? By birth is naturalized. How do you acquire naturalized citizenship? We have by birth, by descent, by registration, by naturalization. That means someone who has stayed in India for a specific period of time, he is eligible to acquire Indian citizenship. So when you acquire citizenship by registration or by birth, you have to express your allegiance. That means you should state that you stand by the Constitution of India. You stand by the Constitution of India. So when you use naturalization, that appears, right? You have to express your allegiance to the Constitution of India. Second, Article 31C is an exception to Article 14. What did we discuss about Article 31C? Why Article 31C was incorporated? It said, 42nd Constitutional Amendment said all directive principles of policies, directive principles of state policy shall acquire primacy over fundamental rights. So they can trump fundamental rights, and including fundamental rights without exception, including 14. Then the directive principles resemble the instruments of instructions, because directive principles are also part of the Government of India Act 1935. And welfare state is not a part of a basic structure of the Constitution. Welfare is. That is why otherwise economic weaker section reservation cannot stand. What did I tell you? Economic weaker section is brought as a constitutional amendment, not as a parliamentary law. When you bring it as a constitutional amendment, it is tested against basic structure. all changes that are brought through amendment, through constitutional amendment tested against basic structure, and welfare state is part of basic structure, so it will pass the test. Clear? If it was brought as a parliamentary act, then it would have rejected. Court would have rejected it because it will test it against due process. Because it is brought as amendment. The method of amendment, testing of the method of amendment is basic structure. So welfare state is part of basic structure. So what is the choice here? Consider the following statements. Which of the above statements are incorrect? First one is correct. Second one is correct. Third one is correct. And what is the last? Fourth statement is incorrect because welfare is part of basic structure. What does the key state? Huh? C. Why C? Yeah, 4 only. 4 only. That is what. What does it mean when India is described as an indestructible union of destructible states? The options are self-explanatory. The options are self-explanatory. The parliament can draw the political map of India according to its will. The constitution authorized the parliament to alter the area's boundaries of the existing states with their consent. Consent does not matter. Territorial integrity of a state is guaranteed by the constitution. No. If it was there, then Article 3 wouldn't have been there. Fourth, all of the above. So self-explanatory, first choice. The parliament can draw the political map of India according to its will. The framers of the Indian Constitution derived inspiration for fundamental rights from. Because where do you need, what are fundamental rights? They are political and civil in nature. They are political and civil in nature, which can be expanded universally. Which can be expanded universally, which can be extended to all. Everyone can get political and civil rights because you are not taking away the rights of anybody else. If right to vote is given to you, right to vote of someone else is not withdrawn. So they are universal in nature and can be expanded to all. So they are part of fundamental rights. And directive principles cannot be universally expanded. That is the reason why they remain non-enforceable. Non-enforceable because directive principles focus on social equality. Equality cannot be universalized, but liberty can be. So fundamental rights are guaranteed under the influence of the American Constitution. Consider the following statements. Judiciary does not fall under the definition of the state under Article 12. Tricky question. When you look at judiciary, Indian judiciary is both independent judiciary and integrated judiciary. When you talk in terms of independent judiciary, then it cannot be challenged. But when you look at integrated judiciary, that means judiciary also controls the administrative functions. All the subordinate courts are controlled by the judiciary, higher judiciary. Then it falls under the definition of state. If you look at independent judiciary, then it does not fall under the definition of state, but integrated judiciary does fall under the definition of state. It is both because executive does not control the administration of judiciary. Executive does not control the administration of judiciary. Higher judiciary exercises supervisory role over the subordinate courts. So the definition falls with respect to the integrated functions, not with respect to independent functions. Second, the rules made by the Supreme Court in the exercise of its powers under Article 145 can be challenged in the Supreme Court. It can be. It can be. What does it support in 145? What is 145? What is 145? Forgot what 145 deals with? 124 to 147 deals with judiciary, and 147 deals with interpretation, 146 deals with the 147 deals with the rules of Supreme Court, like bails and everything. And 145, if I am not mistaken, where it states that the law enacted by Supreme Court is binding on all courts. Right? So the choice is, judiciary does not fall under the definition of state under Article 12. Identify the correct choice. What is your choice? What is the choice? Second. Consider the following statements. The Constitution has not prescribed the qualification of members of the Election Commission. It's a true statement because they are all IAS. There is no qualification as far as the Constitution is concerned. The Constitution has not debarred the retiring election commissions from any further appointment by the government. Even this statement is true. Unlike other constitutional bodies, it has not prevented the retiring election commissions from taking up government job. The Constitution has specified the term of the members of the election commission. Constitution has not defined the term. It is the Parliament which has defined the term. So, which is the right answer here? Which of the statements given below are correct? What is the right choice given with respect to 7? Yeah, wonderful. Yeah, A. 1 and 2. Consider the following statements about elephant bond. This I don't know, but first time I came across what these elephant bonds are. There are 15 years, these are the 15 years sovereign bonds in which people declaring undisclosed income will be bound to invest 40%. What is sovereign bond? Any idea? So, bonds which are issued by this government of India are sovereign bonds. That means government of India stands guarantee. When government of India stands guarantee, that means you are raising funds from people by issuing bonds. By issuing bonds, they are in the nature of sovereign bonds. These bonds are rupee dominated bonds, that is the funds would be raised from overseas market in Indian rupees. The fund made from these bonds will be utilized only for the infrastructure projects. After I came to know about these elephant bonds, then I checked the second and third statements stand correct, excepting for the first statement because of a technical reason there it is not 40% but 50%. Got it? So, this is also a test of memory. Test of memory. In the context of the Indian Constitution, the term liberty refers to, what is liberty? Freedom under social control. So, you have given one straightforward answer for this. Providing opportunities for the development of individual personalities. Absolute absence of restraints on the activities of individuals. Absence of special privileges to any sections of the society. The power or scope to act as one pleases. So, your statement is the most appropriate statement what you are given. Freedom under social control, because second statement does not fit to that. Because you cannot have freedoms absolute. Only American Constitution guaranteed absolute freedoms, but through police state it imposed restrictions. The judiciary has imposed restrictions, not the Constitution. Whereas Indian Constitution, it imposed reasonable restrictions against the fundamental, against the liberty. Within the liberty, against each clause under 19, against each freedoms under 19, the Constitution itself imposed reasonable restrictions. So, they are not absolute. They are not absolute. Second, the Constitution has not, the absence of special privileges. Absence of special privilege is part of equality. The power or scope to act as one pleases. This is also absolute. One pleases means you are talking about absolute. The only choice what is most appropriate among the given choice is providing opportunities for the development of individual personality. This is where I keep stressing on right to freedom of thought. Right to freedom of thought. Which of the following are mentioned as fundamental duties in the Constitution of India? Yeah. The power or scope to act as one pleases. You cannot act without social control. The freedom is limited, right? There are three governing principles: public morality, public order, public security. You cannot go against that. Got it? So, social control, she gave the best answer. Social control restricts your freedom. So when you compare it with social control, because 19 is governed by social control, that is the reason why reasonable restrictions. Which of the following are mentioned as fundamental duties in the Constitution of India? To respect national flag, national song, national anthem, but not song. National flag and national anthem is there, but not national song. Second, to pay taxes. This is what they should have incorporated. Unfortunately, the Constitution did not recognize paying of taxes. And the third, to cast vote. Right to cast was actually, Gujarat government wanted to bring it as a mandatory right. Everyone should participate in election. So this went to Supreme Court. Challenged in Supreme Court. Then Supreme Court did not go with the state ruling. So it said people have their choice. We have to respect the people's choice. So in the process it recognized nota also. None of the above option. None of the above option. You cannot force people to exercise this right. Right? So it is not part of your duty. It was actually thought of making it a mandatory right. That everyone, mandatory duty that everyone should compulsorily participate in election. Gujarat government wanted this, but the Supreme Court, when it was challenged, it discarded that. It said it is people's choice. You cannot force them. Yeah. Still, see, there is some legitimacy acquired, because what this is how Supreme Court started ruling. Even directive principles are non-enforceable. But since fundamental, they are not just duties. They are not just duties. Fundamental. When you use the word fundamental, then Supreme Court started reading fundamental rights, fundamental duties and directive principles together. Right? That is what yesterday also I said, any provision in the Constitution is equally significant. Whether it is enforceable or non-enforceable, that is different. Enforceability because it can be universalized. Non-enforceability because there are certain restrictions. Paucity of resources or paucity of time or paucity of so many other dimensions which are part of it. Then it cannot be enforced. Clear? So none of the above. Which of the following statements are correct regarding Article 4 of the Indian Constitution? Laws made under Article 2 and Article 3 shall be considered as constitutional amendment under Article 368. 4 states it is not a constitutional amendment. 4 clearly states it is not a constitutional amendment under 368. If any territory has to be ceded to a foreign country, it needs an amendment under Article 368. You cannot cede territory. This was the judgment given under the Berubari case. You cannot cede a territory without constitutional amendment. Without constitutional amendment, Berubari case, where the Supreme Court also pronounced a judgment that preamble is not part of the Constitution. So Berubari case, where we wanted to transfer this land boundary enclaves, which we finally succeeded with respect to Bangladesh. This was the case. So it needs a constitutional amendment according to the Supreme Court. Without constitutional amendment, you cannot transfer, you cannot cede a territory to any foreign country. It needs constitutional amendment. So the statement second is, if any territory has to be, first statement is wrong. Shall not be considered. Okay, first statement is right. Shall not be considered a constitutional amendment under Article 368. Clear? So what is the choice? See. The right to property was deleted from the list of fundamental rights by Amendment Act 44. Identify correct statements with respect to the right to equality. Article 14 covers the principles of natural justice. What did I keep telling? 14, 19, 21. The undergoing principle of 14 is justness. Undergoing the principle of 19 is reasonableness. And 21 is fairness. When you combine all three, principle of natural justice, equality is part of natural justice. The concept of equal protection of law is borrowed from the United States Constitution. Equality before law from America, from Great Britain, equal protection of law from America. American Constitution also favored affirmative action, but limited affirmative action. So what is the choice? Which of the following statements are incorrect regarding removal of chairman or any other member of Union Public Service Commission? If he is, in the opinion of the Parliament, unfit to continue in office by reason of infirmity of mind or body, then he can be removed. Parliament does not come in. President. President can remove the chairman or any other member of UPSC for misbehavior only after refers the matter to the Supreme Court for an inquiry. So first statement is wrong. Parliament has nothing to do with the removal. So it is the President. So second statement stands correct. So choice could be A. Consider the following statements regarding Stockholm International Peace Research. I didn't know this. Stockholm International Peace Research Institute. SIPRI is an intergovernmental body dedicated to research into conflict, armaments, arms control and disarmaments. The institute cooperates closely with several intergovernmental organizations like the United Nations and the European Union. Trends in international arms transfer reports were released by SIPRI. And after looking at the key, I realized that it is not intergovernmental but voluntary. It is the non-state actors' participation, not state actors' participation. It is non-state actors' participation, not state actors' participation. So the other two statements stand correct. Consider the following statements. The preamble is neither a source of power to legislature nor a prohibition upon the powers of the legislature. Preamble is neither a source of power for legislature nor a prohibition upon the powers of legislature because parliamentary sovereignty. Parliamentary sovereignty. It is justiciable in the courts of law. Preamble is non-justiciable in the court of law. Preamble is non-justiciable in the court of law. Preamble was added after adopting the constitution. That is where the controversy came, whether it is integral to the constitution or not. Preamble was added after adopting the constitution. So it was considered whether the preamble is integral to the constitution or not. Berubari said not. Keshanand Bharti said it is integral. Wherever we find ambiguity, preamble provides us with the direction. Which question was that? 16. Which of the following are related to Part 4A of the Constitution of India? Yeah. Huh? What is the answer given? This. The preamble is neither a source of power to legislature nor a prohibition about the powers. It is non-justiciable. That is, its provisions are not enforceable in the C. It is justiciable in the court of law. The answer what they have given is C. Which of the above statements are correct? So 1. The explanation correct, but the choice wrongly misprint. Which of the following are related to Part 4A of the Constitution of India? Sardar Swaran Singh Committee. Part 4A deals with fundamental duties. Fundamental duties are incorporated based on Sardar Swaran Singh Committee. He recommended 14 recommendations, but the Constitution adopted only 10. Right? 14 he initially originally suggested. Constitution adopted 10. 42nd Constitutional Amendment in fact brought in 51A. And 86th Constitutional Amendment added 11th duty, the most appropriate duty to Indian society. So which of the following are related to that? All. Which of the following objectives is not embodied in the preamble to the Constitution of India? Liberty of worship, social justice, promote equality among all, dignity of the individual. Liberty, equality, fraternity. Liberty, equality, fraternity, all. Which of the following statements is not a characteristic of the fundamental rights enshrined in our Constitution? They are universal, that is applicable to all the citizens of India. They are justiciable, They cannot be suspended under any condition. This is not correct. Fundamental rights can be suspended other than Article 20 and 21. But unfortunately, under ABN Jabalpur decision, the court even suspended right to life. Suspended right to life. And that is a time when court accepted the sealed cover. What I keep telling, Chidambaram case, sealed cover. Chidambaram does not know on what charges he is arrested. Sealed cover, investigation, they only show it to the judge. If the judge is convinced there is a prima facie case, he can award custody. This is what has happened. He does not know. He does not know on what grounds he is arrested. Judge is convinced. So this is something which is introduced into Indian jurisprudence through this Jabalpur case. Jabalpur case is historic because of these two facts. One, this sealed cover investigation, something which it started accepting into Indian jurisprudence, and it also favored suspension of Article 21 when emergency is in force. Subsequently, this is corrected. Now 20 and 21 cannot be suspended even during emergency. Article 20 and Article 21 cannot be suspended. So they cannot be suspended under any conditions. This stands wrong because only 2021 are exempted, not all. They are sacrosanct and permanent. They are not permanent. They can be changed by the parliament. Article 21, Article 19 and Article 31 both were repealed by the Act of Parliament. Right to property was deleted or repealed by the Parliamentary Act. So they are not sacrosanct and they are not permanent. So only the first two statements stand correct. Consider the following statements regarding the fundamental rights. No fundamental right in the Indian Constitution is absolute. Are there any? If you go with the key, untouchability cannot be guaranteed as an absolute right. Right? And this also I was not aware, frankly speaking. Then I realized these two things. Untouchability, of course, I knew, but not with respect to the children employing in hazardous environment. This cannot be. These both are absolute rights which cannot be challenged. But other than that, all are subject to challenge. The right to carry on a business also includes the right to close it any time the owner likes. Karnataka MLAs challenged it on the same grounds when they offered their resignation. They said, we have the right to resign from any profession, including politician. I can do any business. I can also withdraw from the business. And something Supreme Court strangely, it said, okay, disqualification stands, but you are eligible to contest. Then what is disqualification? What is disqualification? Disqualification is upholded. The decision of the speaker is upholded. Right? This is what Supreme Court said. But you are eligible to contest. Then where is the disqualification? It is as good as accepting resignation. As good as accepting resignation. If Supreme Court said your disqualification is validated, Speaker has the power to disqualify, then Speaker's power if recognized, then Speaker disqualified them at the end of the life of the House. But immediately it follows with the judgment and says that they can also contest. Then where is disqualification? I didn't get that. Instead, Supreme Court says Speaker's jurisdiction does not go beyond their disqualification. So you are only acquired power to disqualify from them House, but now you cannot prevent them from coming back to the House. You cannot prevent them from coming back to the House. So Supreme Court should have elaborated on this disqualification.
Sir, if you read this second statement with respect to IBC, and the person who is having stake on this business, then they will be at loss.
No, that's what they said. They can. This is what Excelware case. Not only Excelware, there are many instances where it was challenged. Then they said, you cannot force me to continue with the business.
So for that,
See, one thing is there, business itself is a risky venture. There is no guarantee that you will earn profit all the time. And if you continue to hold on to business, it may actually deplete whatever surplus that you generated if you are making loss. This is what has happened with Ambani brothers, Junior Ambani.
so anytime they can close it.
They have the freedom. They have the freedom to close.
Then
This is something Supreme Court recognized. Right? You have freedom to start a business. You also have the freedom to close the business.
but in a phased manner, he must close it as well.
Yeah. Because he has to also honor the agreement.
The statement anytime it will contradict this.
Anytime means, see, when I wanted to end the business, I am declaring ending the business. When I will end the business? When I only honored what all commitments that I made as part of my business. Future business I will not do. But you cannot force me from doing future business when I wanted to wind up my business. Clear? So it is subject to interpretation. All constitutional readings, all court decisions are subject to interpretation. When you say anytime, Supreme Court judgment stated that you are free to close your business. Which of the following statements are correct regarding role of Union Public Service Commission? The role of Union UPS is limited. The recommendations made by it are only advisory in nature and hence not binding on the government. It is concerned with the classification of services, pay and service conditions, cadre management, training and so on. It is only concerned with disciplinary. And second statement is correct. Whatever recommendations UPSC makes, it is only recommendationary, but if the government rejects it, it has to give an explanation to Parliament why it has rejected. All your selections are only recommendation. All your selections are recommended, though they are not binding, but as a convention they are accepted. Though they are not binding, as a convention they are accepted. Now they have also introduced a change, I think. The merit is not given by the UPSC, only selection list is forwarded. The merit will be determined of your foundation. After your foundation test, that means it has gone from the UPSC hand to the government's hand. Government will decide who shall be given the merit, right? It only forwards the list of selected candidates. List of selected candidates, and the ball has gone from UPSC to government. Now, if you are favorable to government, you will get a better merit. If you oppose government, then your merit will come down. So it is not with the UPSC anymore. And service conditions, it is Department of Personnel and Training, not UPSC. Disciplinary UPSC. So what is the choice here? What is the choice with respect to 21? A. Biological diversity of areas beyond national jurisdiction. Is it a term relating to which of the following organization? So biological diversity is a very complex word. This should have also included, to at least gain some hint, this question should also included marine biological diversity of areas. When you don't use marine, it is impossible for anyone to at least widely guess that it is United Nations Convention on Law of Sea. United Nations Convention of Law and Sea, it is impossible because biological diversity is so vast. It occupies both land and marine. Okay. Oh, then good. Very intelligent answer. So beyond national jurisdiction, yes. Beyond national jurisdiction means it is hinting at marine. Now I got it. Thank you. So marine, so it is only not focused on land biodiversity, but marine diversity. When it is marine diversity, you cannot have UNEP, or you cannot have Worldwide Fund for Nature, or CITS, this I don't know, but then it comes to Law of Sea. Then it moves, the obvious choice, even without knowing also we can select once it is marine or biodiversity, rightfully pointed out. What is your name? as rightfully pointed out by Sripal, I think once goes beyond the jurisdiction. Jurisdiction means it has to be marine. But beyond the jurisdiction, it could also be land. If it is Nepal, if it is a country like Nepal, beyond the jurisdiction of Nepal, does it have any marine boundary? What?
It is other country.
So what? So what? It is biological diversity of areas beyond national jurisdiction. It is not specific to India. It is not specific to India. United Nations law of sea is not specific to India. But what it would be if a landlocked country?
So even UNCLOS also provide rights to landlocked countries also. Landlocked countries also mentioned in UNCLOS.
So beyond jurisdiction means that also includes land. This is what I wanted to say.
Land is included in another country's territory. That comes under the jurisdiction of another country. That's why it's included again.
So when you say without any common territorial jurisdiction, but common, good. In which of the following cases did the Supreme Court hold the opinion that the preamble is not part of the Constitution for the first time? Berubari. Which of the following provisions in the Constitution cannot be amended by a simple majority of the two houses of Parliament outside the scope of Article 368? There are 4 options given and only election of president is there. Election of president takes place between center and states. The electoral college constitutes both center and states. Even if you don't know the other options also, because you have to select one, your choice is president, because president is elected through an electoral college consisting of members of both parliament as well as state legislatures. Consider the following statement. The governor is empowered to direct that an act of parliament does not apply to a scheduled area in the state. Extraterritorial legislation can be made by president with aid and advice of the council of ministers. Laws enacted by parliament are both apply within the jurisdiction and extend beyond the jurisdiction, not the president's act, not the presidential orders, not the executive order. But the law enacted by parliament can extend beyond the territorial jurisdiction. So second statement stands incorrect. The governor is empowered because it is ultimately the discretion of the governor to extend parliament and state laws to the scheduled areas. So what is the choice? Second option. Dr. B.R. Ambedkar called which of the following article as the most important article and the heart and soul of the Constitution? Constitutional remedies. Constitutional remedies under Article 32. Consider the following statements regarding the fundamental rights. The writ of prohibition is available during the pendency of proceedings. The writ of certiorari can be resorted to only after the order or decision has been announced. What is prohibition and what is certiorari? Certiorari means you are certifying. When you will certify? After the judgment. After the judgment, when it exceeds the jurisdictional limits, it declares the High Court will prevent the lower court from adjudicating the case, or it goes, or whatever judgment it has given, it will overturn that by taking up the case onto itself or a superior court other than the lower court because of jurisdictional limits. And prohibition, stay order, general stay order. That means before the conclusion of the proceedings. Stay order is what prohibits. Usually every government will go and seek stay order. That means you prevent the further proceedings in the case. Prevent further proceeding in the case is what prohibition is. So identify the correct statements. What is the choice? Both. Which of the following provisions are made in our constitution to safeguard and ensure the independent and impartial functioning of the UPSC? The entire expenses including the salaries, allowances and pensions of the chairman and members of the UPSC are charged to the public accounts of India. Consolidated. What is public accounts? What does it continue?
Provident fund.
Not only provident fund, all those court fees, all those challans what you pay for the violation of rules, they are all part of public accounts committee, and all your net tax proceeds go into consolidated fund of India, including your internal and external borrowings. So they are charged expenditure on consolidated fund of India. There is nothing like charged expenditure on public accounts of India. Constitution does not recognize charged expenditure on public accounts of India. It only recognizes charged expenditure on consolidated fund of India. The chairman and member of UPSC is not eligible for further employment in the government. Chairman is not eligible, but members are eligible. A member can become chairman. Member can become chairman, but chairman is not eligible. So both are wrong. Consider the following statements. It is an annual festival at Kamakya temple atop Neelanchal hills of Guwahati, Assam, on the bank of the river Brahmaputra. Yes, you have any question? During the 4-day event, it is believed that the presiding goddess of the temple, Devi Kamakya, goes through her annual cycle of menstruation. I don't know, frankly. Right? So I also rely on the key, and whatever key says, I think it says B. Ambu Bachi Mela. Okay. Consider the following statements. The word secular did not appear anywhere in the constitution before it was inserted into the preamble. The word secular signifies state will protect religion of majority in the state. What is secular? One word answer for secular: absence of discrimination. So it is not just religion but everything else. But since India only pursues things in terms of religion, so it is not majority religion obviously. So second choice stands incorrect. The word secular did not appear anywhere. This is interesting because even I was under the impression that secular and socialist are inserted only through 42nd constitutional amendment. But when I carefully examined the key, they said it is already there as part of Article 25 Clause 2. I think this is a test of memory again. A test of memory. Usually we go with the values, the conceptual values, where you see secular and socialist means blindly we will say 42nd constitutional amendment. During emergency it is inserted into the constitution. That is why BJP is opposing it. I thought BJP is opposing it because it is introduced during emergency. When you have put every opposition leader in jail and brought this constitutional amendment. It is not because it is essentially opposing it. It is not essentially opposing it, but because amendment was brought under emergency. During emergency, you put all the opposition leaders in jail and brought this for constitutional amendment. So that is the reason why they have reservations. This is my understanding. So it is not that secularism is already there in the constitution. They are opposed to it because of religious reasons, not because the opposition was put in jail. So what is the choice? Choose the incorrect statement. Second one is incorrect. First one says it is already there in the constitution under Article 25 Clause 2. Both are? The word secular did not appear. Did not appear. Yes, both are incorrect. Right. The features of Indian federal system are, what are the features of a federal system?
There is nowhere secular word is written, but then secular values is there.
So secular word, they are telling secular.
Word is not there. Word was there only.
They mentioned in that right to carry on any secular activity in education.
Secular word is there.
Not as a value, but the word is.
Right? So this is a memory test. Memory test. Okay, even I was not, see who will look so particularly and think in terms of that. Usually we think a value. That is how you try to understand things. So the features, Indian federal system, what are the features of any federal system? What do you need? There has to be dual government. There has to be distribution of powers. Here they say division of powers, distribution of powers. Then third, there has to be a written constitution when there is distribution of powers, supremacy of the constitution, and independent judiciary to protect the constitution. And among this, what all we have? Division of power is there. Single constitution is a unitary feature because this is not part of the constitution. When you have a federal system, you should have dual constitution. Separate constitutions like American constitution. That is why it is recognized as a classical federation, the best federation. Independent judiciary is also essential. Integrated judiciary is not a necessary condition, a written constitution. So 1, 3 and 5. 1, 3 and 5 form federal system. The features, choose the incorrect statements. Then the 2 and 4. Huh? What is the incorrect statement then? 31. Where is 31? One moment. Let me check that key. 31 they have given D. 1, 3 acha. The choice is wrong. Choose the correct statement. So let me make a correction here so that I will inform them. Otherwise this remains as it is because everyone will think the same thing is. Which of the following features are incorrect about fundamental rights guaranteed by the Constitution? Fundamental rights are absolute in nature. They are not. They came with reasonable restrictions. They are defended and guaranteed by the legislature and executive organ of the state, by judiciary. Article 13. They can be amended only by the parliament, not by state legislature. Only parliament has the power to amend the constitution, not the state legislatures. So which of the following features are incorrect about fundamental rights? What are incorrect? Fundamental rights are absolute. Incorrect. They are defended. Incorrect. So 1 and 2 remains incorrect. They can be amended only by the parliament, not by the state legislature. Stands correct. Which of the following writs is issued by the Supreme Court to command government health professional on strike to go back to their duties? Whenever Supreme Court commands, it is mandamus. Whenever Supreme Court commands, it is mandamus. And what is continuing mandamus? When Supreme Court also takes up investigation, then it is continuing mandamus. The protection of Article 21 is available even to convicts in jail. The convicts are not, by mere reason of their conviction, deprived of all fundamental rights that they otherwise possess. Which of the following rights does not arise out of Article 21? Even if you are not aware of this, anticipatory bail cannot come when you are in conviction. What is anticipatory bail? Before you are convicted. Before you are convicted, that is part of anticipatory bail. So rest 3 are part of Article 21. Right to fair trial, right against delayed execution, right to write a book, they are all part of Article 21. Anticipatory bail does not come when you are detained. It only comes prior to your detention. Prior to your detention. So it is not part of 21, but part of 19 freedom, you can say. Which of the following statements are correct regarding composition of State Public Service Commission? The Constitution does not specify the strength of the Commission but has left the matter to the discretion of the President. 1/2 of the members of the Commission should be such persons who have held office for at least 12 years. Constitution only talks about 10 years. Either under Government of India or under the... It does not maintain any distinction between UPSC and the state, 10 years of service. So statement 2 is wrong. Consider the following statements in the context of government efforts to reduce the incidence of tuberculosis.
is governor side, the case of SPSC, state public, it is written president.
The constitution does not specify the strength of the commission, but
President.
Governor,
it should be governor.
Commission, but has left the matter to the discretion of the president. The constitution does not specify the strength of the commission, but has left it to the discretion of the governor. Let me see. Governor. Okay, both are wrong then. Consider the following statements in the context of government efforts to reduce the incidence of tuberculosis. Under mission Indradhanush, what is Indradhanush? Rainbow vaccination, not for TB. It is not for tuberculosis. And what is that we have done with respect to tuberculosis? So that is something different. And this is it's a program which cannot be stopped in between. Because most of the people in India, once they think that the symptoms are relaxed, they stop taking medicine. Once it revives, then there is no cure. So now the Anganwadis, Asha workers are also associated with this. They have to identify, trace, keep a record, chase them till they complete the course. So they are in the process also incentivized. Once they identify, they are also, it's a long process. It is not one dose or two dose. So it is not part of your Indradhanush. And Niti Aayog released National Strategic Plan to end TB in India by 2025, well before the deadline of Sustainable Development Goals. We know about Sustainable Development Goals, but we don't know whether Niti Aayog in fact had this 2025 as the achieved Millennium Development Goals or the halting, reversing the incidence of TB. National Strategic Plan to end TB in India by 2025. Right? Released in this framework. So what is the question? Choose the correct answer using the quotes given below. It should be B. It should not be A. Vaccine preventable diseases. Tuberculosis is one of the diseases. Revised National TB Control Program is being implemented under the umbrella of National Health Mission, which has achieved global benchmark of case detection and treatment success and achieved Millennium Development Goals in 2015 of halting and reversing the incidence of TB. National Strategic Plan to end TB in India by 2025 released this framework in 2017 for the control and elimination of TB in India by 2025. It provides goals and strategies for the country's response to the disease during the period 2017 and 2025 and aims to direct the attention of all stakeholders to the most important intervention to eliminate TB. 2 is correct, 1 is not. Make the correction. 36, no?
Sir, I guess TB is part of Untitled. TB is part of Untitled.
Childhood tuberculosis. Anyway, I am not aware of this. I leave it to you. Consider the following statements regarding the Constitution. Indian Federation is a result of agreement between the units which it is made of. Is it? We are a Canadian Federation, holding together, not coming together. We are not coming together federation, we are holding together federation. India was already a union at the time of Constitutional Assembly debate because 1935 Act created Indian Federation. 1935 Act created Indian Federation. So we were already a union prior to the Constitutional Assembly debates. Statement 2 is correct. And India is not a coming together federation, but we are holding together federation. Which of the following is correctly stated about 97th Constitutional Amendment? It gives constitutional... 37, what is the answer they give? B. B. Consider the following statements regarding Indian Federation is a result of agreement between units. So answer is what they have given is B. Wrong. Which of the following is correctly stated about 97th Constitutional Amendment? It gave constitutional status. Let me check 37. Is talking about the same thing in terms of explanation. Which of the following is correctly stated about 37th Constitution? 97th Constitutional Amendment. It gave constitutional status and protection to cooperative societies. It added a new part, 9B, to the Constitution. Both are true. Both are true. So, answer is C. 39th. Which part of the Constitution seeks to establish economic and social democracy in the country? It cannot be fundamental rights. It has to be directive principles of state policy. Consider the following statement. State legislatures have the power to make a law to give effect to certain specified fundamental rights if the matter falls within the state list. Parliament can empower courts other than Supreme Court and the High Courts to issue writs for the enforcement of fundamental rights. Parliament acquires this power. Parliament acquires this power. Constitution has provided under Article 32 and Article 226 to both Supreme Court and High Court, but Parliament also acquires the power to extend this. So, what is the right choice? 40. 2 only. Which of the following fundamental right can be suspended during national emergency? Which can be suspended during national emergency? Right to privacy, right to travel abroad, right to freedom of profession, right to decent environment. Freedom of profession comes under Article 19, rest or follow part of Article 21, which cannot be suspended. Consider the following statements regarding Joint Public Service Commission. A Joint Public Service Commission can be created by an act of concerned state legislature on the recommendation of Parliament. Is it true? On the recommendation of President. The chairman and members of a JPPC are appointed by Parliament. Is this true? They hold office for a term of 6 years or until they attain the age of 65 years. The Government of India Act of 1935 provided for the establishment of Joint Public Service Commission. Whenever it comes to state, it is 62 years, not 65. So, 65 years is a wrong statement. The chairman and members of JPSCs are appointed by the Parliament. Parliament has no business. It is executive. So, it is part of President. And the Joint Public Service Commission can be created by an act of concerned state legislatures on the recommendation of President. Parliament. So, only statement which is correct is 1935 Act. 4th. Consider the statements in the context of data localization. Data mirroring is a form of data localization. Where from they get these questions? Is it part of current affairs? Data mirroring is a form of data localization. Right now, there is no mechanism for requesting and obtaining evidence for criminal investigation and prosecution with respect to cyber data. In many countries like US, tech companies are legally barred from disclosing data to foreign law enforcement agencies. When you don't know, go with the key. 43D.
Sir.
Yeah.
But in the key they said statement was false. But they still
Let me choose. 43.
in the key, the second last sentence, they gave statement was false.
40?
43, sir.
Yeah. It may restrict flow entirety or so data mirroring is just a version of data localization and it is not different from it. Right now, India depends on mutual legal assistance treaties. Hence, statement 2 is false. No data mirroring is just a version of data localization and it is not different from it. What is this 2? Right now there is no mechanism for requesting and obtaining evidence for criminal investigation and prosecution with respect to, they are talking about mutual. And it is not different from it. Right now India depends on mutual legal assistance treaties. So here it is talking about obtaining evidence for investigation and prosecution with respect to cyber data. There is no mechanism. It is like extradition treaty. It is similar to extradition. Mutual means, what is extradition treaty? Where you enter into some reciprocal extradition, where if you have someone criminal taking shelter in another country, if you have an extradition treaty, you can, like with Great Britain, we have extradition treaty where we could call back Malia or Nira Modi. Or with Portugal, we had the extradition treaty to call back Abu Salam. Right? So they are part of this mutual agreement. You are right. So it is subject to interpretation, and their mutual agreement, does it mean any mechanism? Then if it is not a mechanism, then extradition treaty is also not a mechanism. So I'll also discuss with them with this market. With reference to the power of parliament, was this question asked in current affairs? Then the same choice was there. With reference to the power of parliament to admit into union or establish new states, there is a need for a law to be passed by the parliament to acquire new territory. There is a need for a law to be passed by parliament to establish new states. You need parliament. So both 1 and 2. Consider the following statements. The state administrative tribunals are established by the union government. The chairman and members of the state administrative tribunals are appointed by the governor of the state. Are the members appointed by the governor of the state? 45. President after consultation with the governor. The Administrative Tribunals Act 1935 specify request of the concerned state government, central government. Okay. So statement 2. It is president in consultation with governor. So the choice 1 is the right choice. Dadar and Nagar Haveli was converted into a union territory of India by the 10th constitutional amendment. When did Goa got annexed? 1962. The state of Nagaland was formed by taking the Naga Hills and Tansang area of the state of Assam. Except Manipur, all other states of Northeast are carved out of Assam. Manipur was a princely state. The union territory of Himachal Pradesh was elevated to the status of a state. All three stand correct. Order 1960s, 1970s, 1980s, 1, 2, 3. Consider the following statements. With respect to CVC, the members of Central Vigilance Commission are appointed by the President by warrant under his hand and seal on the recommendation of a 3-member committee consisting of the Prime Minister as its head, the Speaker of Lok Sabha, it is not Speaker, Home Minister, and the Leader of Opposition. So discard the first statement. They hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. The Commission is empowered as the only designated agency to take action against complaints making motivated or vexatious complaints. Which of the following is true? First statement is in fact wrong because Speaker is nowhere involved. It is the Prime Minister, the Home Minister and the Leader of Opposition. So what is the right choice? 47, C. Okay. They hold office only for 4 years. Even I was not aware of it. 6 years I thought, because usually constitution goes with same standards. 6 years or 65 years, wherever they make appointment. This is the same standard. So here CVC has come with 4 years. Okay. So only B, only 3. The commission is empowered as the only designated agency is the right choice. Following are the statements regarding the test of essential practices, core practices. Core practices to adjudicate on issues of right to freedom of religion. What constitutes an essential part, core practice of religion, is primarily to be ascertained by the reference to the doctrines of that religion only. The test of core was first laid forth by the Supreme Court in 1954 in Shirur Mutt case. Both statements are true. First time it engaged with this core practice was with Shirur Mutt case. So both 1 and 2 stand true. So essential practices means core practices. Court or state cannot intervene with. Court or state can only intervene with peripheral practices, not core practices. With reference to the Finance Commission of India, which of the following statements is true? One of the members of this commission should be a judge of High Court or should be qualified to be appointed as one. Its recommendations are binding on the government. Chairman and members of the commission are not eligible for reappointment. None. It has one of the members as a High Court judge. Its recommendations are not binding, but they have to give an explanation to the Parliament. Finance Commission recommendations are not binding, but accepted, like UPSC. Third, chairman and members of the commission are not eligible. They are eligible. They are eligible. So only statement 1 stands correct. A. Which of the following statements are right in the context of UN Women? It is a United Nations entity established in 1945 on the sidelines of Bretton Woods Conference dedicated to gender equality and the empowerment of women. Recently, the UN Women released its new report titled Progress of World's Women 1919-20, Families in a Changing World. It emphasizes the objectives of women-led development. Which of the following statements are correct? Any idea? Why? You went with the key?
Yes.
So there is no dispute. It says it's 2010, not 1945. 51. Consider the following. The Fazal Ali Commission accepted language as the basis of reorganization of state and the theory of one language, one state. It is a mistaken identity because it is also identified as a linguistic reorganization of state. It is not linguistic. Fazal Ali Commission opposed. Fazal Ali Commission opposed to the formation of states based on linguistic. That is the reason why it is only to be identified as state reorganization, not linguistic reorganization. Not linguistic reorganization, it is state reorganization. He opposed to the formation of one language because it goes against nation building process. Nation building process. The committee was of the view that the unity of India should be regarded as the primary consideration in any drawing of the country. Nation building, unity of the country is what is needed. So it is a misnomer to think that Fazal Ali Commission supported, though in some books it appears a linguistic reorganization. It is not linguistic. It is not linguistic. The idea of linguistic he did not support. He only supported unity and administrative convenience. Why it is identified as linguistic? Because he joined all this, created Karnataka, Maharashtra and Andhra Pradesh. So they assume that he has formed states based on linguistic identities. Fazal Ali Commission was opposed to this. Got it? Consider the following statements about State Human Rights Commission. The chairperson and members hold office for a term of 5 years or until they attain the age of 65. Human rights, they are post-retirement, so it is 70. Usually Supreme Court retired judges are also appointed as human rights. This is also led to a dispute because Supreme Court, High Court judges can have practice, but Supreme Court judges are prohibited. High Court judges, they can also practice in Supreme Court or in any other high court other than high court where they worked. They can, but not Supreme Court. So there is some bar on Supreme Court, but what has happened, wherever you give a favorable judgment to the government, you are either appointed as a governor, or you are appointed as Chairman National Human Rights Commission. This is what has happened with Justice Balakrishnan. Controversy. Because then everyone started examining the past 3 months cases that he delivered. Was he favorable to the government? Was he favorable to the, because suspicion, needle of suspicion comes if you are appointed. But there is no other provision. So that is the reason why they enhanced the age to 70 years. NHRC chairman can have an age of 5 years or 70 years period. Yeah. Is it? I didn't come across. 3 years? SHRC. So if it is 3 years, then we have to. Are you authentic? Fine. Then make it 3 years. The chairperson and members hold office for a period of 3 years or until they attain the age of 70. That they have not reduced. Then it makes justification because at least 6 months gap should be there. After you demit office, you should not be provided with any other government employment for 6 months. Then there is some objectivity. But if you are made immediately like Governor Sadashivan, the needle of suspicion. Then they think he has favored the government in terms of his judgment.
The reason they gave was that they are not able to fight the committee.
Whatever it is good because 6 months gap should be there. 6 months gap is essential so that your independence is maintained. Otherwise, you come under political influence. Consider the following statements. The fundamental rights guaranteed under Article 20 get automatically suspended during national emergency. They don't, 2021. The fundamental rights guaranteed under Article 19 can be suspended only when emergency declared on the grounds of armed rebellion. It can be suspended through the proclamation of President anytime, whether for national or national emergency or internal emergency or external emergency. Their application cannot be restricted while martial law is in force in any area. So they chose the incorrect one. Wow. Chose the incorrect one. First statement is correct. The first statement is incorrect. The fundamental rights guaranteed under 20 automatically it is incorrect. The fundamental rights guaranteed under 19 can be suspended only when emergency declared on the grounds incorrect. Their application cannot be restricted. Their application cannot be restricted when martial law is in force. Incorrect. All of the above. What is the choice given? 53D. Yeah, all of the above. Consider the following statements. The CBI is a statutory body that derives its powers from the Delhi Special Police Establishment Act. Is it a statutory body? Delhi Police is a statutory body. It can inquire or cause an inquiry or investigate to be conducted into any complaint against any member of All India Services wherein it is alleged that he has committed an offence under the Prevention of Corruption Act 1988. Which of the following statements given below are correct? Prevention of Corruption Act. First statement is wrong. Second statement is wrong because Prevention of Corruption Act comes under CVC. Central Vigilance Commission. Identify the fundamental rights which are available only to the citizens of India. Freedom of conscience and propagation of religion, 15, 16, 29. Protection against arrest and detention, right to elementary education, right under Article 19. So only Article 19 exclusively for citizens of India. All other three apply to both citizens and foreigners. Consider the following statements. The 89th Constitutional Amendment Act provided for the establishment of a high-level multi-member National Commission for SC/STs in the place of a single special officer for SC and STs. The 65th Constitutional Amendment bifurcated, it is the opposite. 65th created the national and 89th bifurcated. 89th Amendment bifurcated the national commissions, and 65th created a unified commission, replacing the special officers. So choose the incorrect statements, both 1 and 2. Both 65th created unified national commission for SC and ST, 89th bifurcated. Here what it is telling, 89th created a unified body, and 65th. You cannot have something before that happening, right? So both 1 and 2. Global Trends report is published recently by which of the following organizations? When I read that question, I thought World Economic Forum. Global Trends. Because UNICEF cannot deal with global trends, or Food and Agriculture Organization, but UN High Commission for Refugees. This is a very vague question. Usually when trends are associated with economy, and here you have applied it to refugees. The migration, trends in migration. Trends in migration. So we go with the choice. My original intuition was economy. So I thought World Economic Forum. So you also chose the same thing. Consider the following statements. In 1974, Sikkim expressed its desire for greater association with India. Accordingly, the 34th, 35th and 36th deal with Sikkim. 35th Constitutional Amendment conferred Sikkim with an associated state status, right? And 36th made it a permanent state. 35th Constitution Amendment created associate state. 36th permanent state. It removed that associate state. And when it was associate state, the third statement was true. A new Article 2A. Article 2A and a new schedule was inserted, which was deleted by 36th Constitutional Amendment. 35th Constitution, it is not 34th. So 35th Constitutional Amendment. So 1 and 3 correct. Consider the following statements. William Bentinck was made the first Governor General of India after the implementation of the Charter Act 1833. Indian Legislative Council was established by Pitt's India Council. When did Indian Legislative Council appear? 1853. First time Indian Legislative Council. Legislative Council was created. Lawmaking in India began only in 1853. So open competition for civil services was introduced by British through the Charter Act. Macaulay Committee is related to civil services. Except 2. So except 2. 1, 2, 4, 1, 3, 4. 1, 3 and 4 are correct. C, 59. Yeah. 60. Which of the following statements are correct regarding the writ prohibition? So many are there on writ today. It is issued by a higher court to a tribunal. It is issued only against judicial and quasi-judicial authorities. When you say higher court against a tribunal, because tribunal acquires high court power. Tribunals acquire high court power according to Article 323 A and B. So you can contest the judgment of tribunal only in Supreme Court. You can contest the judgment of tribunal only in the Supreme Court. It is issued by a higher court to tribunal. But tribunals, there are also other tribunals like income tax tribunal, customs tribunal only. So Article 323 A deals with election tribunals, B with all other tribunals like SAT, State Administrative Tribunal, Central Administrative Tribunal, Income Tax Tribunal. So there are multiple tribunals which are in place. And what is a tribunal? What is a tribunal? It is not judiciary, quasi-judicial in nature. Even bureaucrats are members. When you have income tax tribunal, assistant commissioner income tax, he is adjudicating the case. He is adjudicating the case. So it is tribunal, it is not judiciary alone. Right? So it is issued by a higher court to tribunal, in which case higher court can intervene. It can intervene with the proceedings of the income tax. It is issued only against judicial and quasi-judicial authorities. It is issued, stay order is issued against judicial and quasi-judicial. It is a stay order. So it applies to both 1 and 2. Consider the following statements in the context of Lok Sabha, Lokpal and Lokayukta Act 2013. Lokpal cannot take suo motu proceedings against any public servant. Anonymous complaints are not allowed as per the Act. Lokpal and Lokayukta Act amended the Delhi Special Police Establishment Act and made a change in the composition of the committee related to the appointment of the director of CBI. It states that where there is no recognized leader of opposition in the Lok Sabha, then the leader of the single largest opposition party in the Lok Sabha would be a member of that committee. And this is one of the reasons why even Information Commissioner's appointment was withheld in the absence of leader of opposition. Leader of opposition, because leader of opposition needs minimum of 10%. 10% of the total membership of Lok Sabha. So if you don't get 55 seats, the leader of opposition remains vacant. Leader of opposition remains vacant. So this has amended to include the largest opposition party, member of the largest opposition party to be recognized as the leader of opposition. So what is the choice here? 61? 1 and? Why it is incorrect?
The key says that the change was made not directly by the ASP amendment, not by Lokpal and Lokayukta Act to the
Okay, there is a further amendment to that. Another amendment, Delhi Special Police Establishment Act 2014 made a change in the composition of the committee related to the appointment of the director of CBI. It states that this question will come this time because there was a controversy with CBI. Both director and the additional director got engaged in some loggerheads, right? You can expect one question. I am expecting a descriptive question also. I am expecting a descriptive question because they are asking on all constitutional bodies. Last time they asked on Election Commission, this time on CAG. So next time they may ask on CVC. Central Vigilance directly, because CBI works brought under this. So you may expect one question on CVC because of the controversy that raised 6 months back with respect to the appointment of CBI director, right, who was forced to go on leave, and Rakesh Asthana was the government choice. Now there is a talk, I don't know how far it is true, but Andhra CS is appointed as CVC. I didn't come across anywhere in the news. LV Subramaniam. I didn't come across because CVC cannot have someone with a tainted past. And that is why he was denied CS, Chief Secretary position, and Jagan Mohan Reddy brought him as Chief Secretary. In fact, Election Commission brought him as the Chief Secretary because he was the senior most just before the elections. So CVC may not go, but I don't know because whether it's a social media message which I came across. Then I tried to refer in newspapers because it needs consultation. Consultation with the 3-member committee. You cannot just appoint him to the position of CVC. So I was referring to the news, but I never came across. But maybe some gossiping which also goes on. Maybe is anticipated to be posted as. Anticipated to be assuming the charge of CVC. So go with the key because they are talking about the 2014 Act as part of this. So it is 1 and 2. Consider the following statements. The Constitution of India is the result of rights of individuals. What does the statement mean? First you tell me before you tell no. Don't go with the key.
are natural in some sense, the constitution came from.
So this is only American Constitution, where it tried to establish based on natural rights theory. So not Indian Constitution. No civil or criminal proceedings can be instituted against the governor of a state under any circumstances. Civil cases can be. Governor can be called as a witness also. Governor can be called as a witness. So it only prohibits from criminal. So the Constitution of India is the result of rights of individual. Both statements are incorrect.
Sir, is it available to present?
Yes.
Only
Civil. With reference to the National Commission for Scheduled Tribes, which of the following statements is false? It is a constitutional body established by Article 338A. 338 for Scheduled Caste. One of the functions of the Commission is it can take measures to ensure full implementation of the provisions of Panchayat extension to the scheduled areas. One of the powers of the Commission is it can summon and enforce the attendance of any person from any part of India and examining him on oath. All of the above. First statement itself is wrong. It is 338A, not 338. So what is the answer? What is the answer for this? Is he asking, which of the following statement is false? I was only looking for incorrect. So here they have given false statement. In the context of Pradhan Mantri LPG, panchayats consider the following. Each panchayat brings together about 100 women LPG customers and an interactive platform to discuss about safe and sustainable usage of LPG. The event is held for promotion of Pradhan Mantri Gramin Kaushal Yojana, Ujjwal Yojana. Only one is correct. Which among the following would be considered as laws made to amend the Constitution? Laws made for admission or as laws made to amend the Constitution. Which one of the following would be considered as laws made to amend the Constitution? Laws made for admission or establishment of new states, formation of new states and alteration of areas, boundaries or names of existing states, transfer some territory to Pakistan. Anticipated? Is it anticipated question? Transfer some territory? This only needs constitutional amendments, not otherwise. Not otherwise. Consider the following. Satyendra Prasad Sinha is the first Indian to join Viceroy's Executive Council under 1909 Act. Yes. Minto Morley reforms provided separate representation to Jamindars. Lord Warren Hastings was the first Governor General of India. Lord Canning became the first Viceroy of India. Which of the above statements are incorrect? What is your choice? Who was the Governor General? William Bentinck. So 3. In the light of Indian Constitution, promoting the ideal of political democracy can be seen in. Where did we find political democracy? Political and civil rights, I said fundamental rights. Where did you find political democracy or political rights in Indian Constitution? Where do you find political rights under the Indian Constitution? Where? Under Article 19, right to form association, right to assemble, they are all part of your political democracy. Right to form association means right to form a political party. Right to assemble, they are all part of your political democracy.
Association and all will also come under DPS.
Where?
So panchayats we can see as a way of political.
Panchayat is a later addition, but it is not fundamental rights. See directive principle, the option given is in the light of Indian Constitution, promoting the ideal of political democracy can be seen in directive principles of state policy or fundamental rights. Yeah? Achha, both A and B are part of it.
And the political party is divided by
No.
We have to follow
No.
the choice.
The choice.
But it's not
It is fundamental.
Sir, to organize
It is-
panchayat and endure them with necessary power and authority to enable them to function as a unit of self-government.
Organized village panchayat.
It is also a political democracy.
Organized village panchayat. But you see, the question is in the light of Indian Constitution promoting the ideal of political democracy can be seen.
Policy B also talks about to promote voluntary formation, autonomous functioning, democratic control and professional management.
Can be seen. Can be seen. When you say fundamental to governance, but non-enforceable. Fundamental to governance, but non-enforceable.
But the word ideal
Fundamental to governance, but non-enforceable, whereas political democracy is enforceable under fundamental rights. There it remains non-enforceable. It is only instrument of instructions. Whereas political democracy is part of your recognized fundamental rights. Enforceable, justiciable. Yeah. Promoting the ideal. Ideal is a value. Ideal, value of political democracy can be seen. So it is subject to interpretation. If you strictly go with interpretation, you can include even directive principles are also fundamental rights only. Directive principles are fundamental rights only, but they remain non-enforceable because we did not have the requisite infrastructure to make it possible. So we may maintain a separate category. Otherwise, they are also part of fundamental rights. And that is what Supreme Court is doing. Converting directive principles into fundamental rights under Article 21. Got it? Consider the following statement. The superintendents of Delhi Police, Delhi Special Police Establishment vests completely with the central government after CVC Act. The director of CBI has been provided security of 2-year tenure in office by the Lokpal Act. This has come. You cannot change him. You cannot change him. That is what led to the controversy with respect to the CBI director 6 months back, just before the election. So the superintendents of Delhi Special Police Establishment vest completely with the central government after CVC Act. Does it come to central government? 68. Okay, vest with the central government, save investigation of offences under the Prevention of Corruption Act 1998, in which the superintendent is the Central Vigilance Commission. Okay, so what is the choice here? Both 192, 68, both 192. So 192 are correct. Why? Which of the following statements are incorrect? The superintendents of Delhi Police, here the key states it is establishment vests with the central government, save investigations of offences under the Prevention of enactment of CVC Act 2003. The director of CBI as Inspector General of Police, Delhi Special Police is responsible for the administration of the organization with the enactment of CVC Act 2003. The Superintendent of Delhi Special Police Act established with the central government, save investigation of offences under the Prevention of Corruption Act 1988, in which the superintendent vests with the Central Vigilance Commission. The director of CBI has been provided security of 2-year tenure in office by CVC Act 2003. Okay, it is Lokayukta Act 2013. Superintendent Delhi Police Special Establishment vests completely with the central government. Establishment with the central government, save investigation of offences under its Prevention of 88 Act.
Not completely with the central government.
Part of it.
Except for corruption.
Except for coercion, everything comes under this. So, second question comes with, which was the question? 68. So, the director, it comes under Lokayukta, not Lokayukta Act, but CVC Act 2003. The second statement is wrong. The first statement is also wrong. So, part of it comes under it. So, the choice is C. Incorrect statements. Okay, let me go with this key. Why waste time? Identify the correct statement from the following. According to the provisions of the Article 37, directive principles are non-enforceable by the court. Doctrine of harmonious construction is proposed to avoid a situation of conflict with, while enforcing directive principles of state policy and fundamental rights. Keshanand Bharti case is a classic example for harmonious construction. Keshanand Bharti, where it tried to harmonize directive principles with fundamental rights. Reconciliation of directive principles with fundamental rights under Keshanand Bharti case, and Article 37 in fact states them they are non-enforceable. So, both 1 and 2 are correct. Consider the following statements regarding Special Officer for Linguistic Minorities. Constitution does not specify the tenure and service condition of Special Officer for Linguistic Minorities. It is true. Article 350A of the Constitution empowers the Parliament to appoint a Special Officers for Linguistic Minorities. 258A states mother tongue. 350B talks about Special Officer. So, we choose the correct statement. Which one is the correct statement? Constitution does not specify is the correct statement. It is Fazal Ali Commission which recommended, not the Constitution. Fazal Ali Commission, state reorganization which recommended, not the Constitution. And 350A deal with mother tongue, 350B deals with special officer. Which of the following statements are true in the context of UN Commission on International Trade Law? Membership does not entail any additional financial contribution, as International Trade Law is a permanent commission of the General Assembly. International Trade Law is a core legal body of the United Nations except in the field of international law. This is a memory testing question only, 71. It is a permanent body, that is fine. The General Assembly elects members for every 6 years. And what is the second question? 71.
Core legal body in international.
Is a core legal body of the United Nations system in the field of international relations. It does not include all the other laws, only trade law. So, it is not a legal body. So, the choice is only one, is a permanent commission of the General Assembly. Consider the following statements. Rights against discrimination on grounds of religion, race, caste, sex, place or birth. Right to equality of opportunity in the matter of public employment. Right to freedom of speech and expression, assembly, association, movement, residence and profession. Which of the above rights does the Constitution confer on the citizens of India and deny the same? All three. 19, 15, 16. 15, 16, 19, 29 exclusively for citizens of India. So, it is 15, 16, 19, all three are part of it. The Government of India Act 1919 provided communal representation to 6 Anglo-Indians and Indian Christians. All. In the Constitution of India, equal distribution of material resources of the community for the common good are included in the directive principles of state policy. Consider the following statements in the context of Gram Nyayalayas. Gram Nyayalayas are presided over by a Nyayadhikari who will have the same power, enjoy the same salary and benefit of a judicial magistrate of first class. Nyayadhikari are to be appointed by the governor in consultation with the respective High Court. The Gram Nyayalayas have both civil and criminal jurisdiction over the offences. It is not governor but the state. Consultation with the High Court, state governments appoint. So, what is the choice given? Which of the above statements are true? 1 and 3 I think is what it deals with 75. 75. Yeah, 193. The Gram Nyayalayas are presided over by a Nyayadhikari who will have the same power, enjoy the same salary and benefits of a judicial magistrate of first class. And the Gram Nyayalayas have both civil and criminal jurisdiction over the offences. They are not appointed by the governor. They are appointed by the state government in consultation with the High Court. Consider the following statements. In Champakam Durai Rajan case, the Supreme Court held that all fundamental rights are superior over directive principles of state policy. In Golaknath case, the Supreme Court held that fundamental rights cannot be abridged or diluted. Golaknath case is clear. Champakam Durai Rajan, what did it speak about? What did it promote, Champakam Durai Rajan? It prevented Brahmins exclusively, and she was a Brahmin who challenged it. It prevented because Madras government has enacted a law preventing Brahmins from getting admission into higher medical colleges. 40% of the seats were reserved for non-Brahmins, and she challenged it under right to equality. She challenged it under right to equality. How can the state enact a law discriminating in terms of caste? Article 14 was challenged. The court supported affirmative action, but it cannot be based on excluding one particular community. Right? Government can enact laws. Reservations is a possibility because not based on alienating one particular community. And this is what led to identification of OBCs. Identification of OBCs and the constitution of Kaka Kalekar Committee. Kaka Kalekar Committee. So what is the right choice here? Both. In Champakam Durai Rajan case, the Supreme Court held that all fundamental rights are superior over directive principles. It did not specify that all fundamental rights, but it is inferred that right to equality is over and above the directive principles. Inferred, but it did not reject. It did not reject. But in Golaknath, it clearly said fundamental rights cannot be abridged. So both 1 and 2. With reference to the Attorney General of India, he must be a person who is qualified to be appointed as a judge of the Supreme Court. His remuneration and term of office is fixed by the Constitution. It is due during the pleasure of the President. His duty is to give advice to the Government of India upon such legal matters which are referred to him by the Parliament. He enjoys all the privileges and immunities that are available to a member of Parliament. 1 and 4. 2 and 3 incorrect. His duty is to give advice to the Government of India upon such legal matters which are referred to him by the President. And he enjoys all the privileges and immunities that are available to a member of Parliament. Which of the following places are in wrongly mapped? Port of Hadida, Kaliningrad, Caspian Sea, Baku, Baltic Sea, Rome, Tyrrhenian Sea. What is the choice? What is the choice? 2 and 3. 2 and 3. That means C. 78. Anyway, I am not interested in even retaining that. Fine. The Citizenship Act of 1955 mentions which of the following as criteria to obtain Indian citizenship. 1955 identified 4: birth, descent, registration and naturalization. Not application. Not application. So choice 4 is removed. 1, 2 and 3. Birth, descent and registration. According to the Government of India Act 1935, the correct statement would be diarchy was abolished. This diarchy is not created at the center. It proposed to creation of diarchy at the center. It is not abolition of diarchy at the center. Abolition of diarchy at the provinces. Introduced bicameralism in all provinces. Not all provinces have bicameral, only 6. Provisions for the establishment of RBI, Federal Police Service Commission and Federal Court. Residuary powers are given to the central. No, it is given to the Governor General. Residuary powers are with the Governor General. On his discretion, he can assign that powers either to the union government or provincial government. Only C. Correct statement is C. Out of the following statements, choose the one that brings out Gandhian principles of directive principles. To organize agriculture and animal husbandry on modern and scientific lines. Usually we go whenever you find agriculture and animal husbandry, Gandhian principle. To prohibit the slaughter of house cows, calves and other milch and draught cattle and to improve their breeds. To secure a living wage, a decent standard of life and social and cultural opportunities for all workers, this is a liberal principle. To raise the level of nutrition and the standard of living of people and to improve public health, they are not Gandhian. They are not Gandhian. So whether agriculture or cow slaughter, which is Gandhian principle? Agriculture is also, because he focused on that, but not this scientific agriculture. With reference to directive principles of state policy, identify the incorrect statements from the following. DPSPs are laid in general terms, whereas fundamental rights have been laid down in clear legal language in Constitution. 25th Amendment introduced a new Article 31C. DPSPs cannot be implemented. If they cannot be implemented, then why have them as part of instrument of instructions? If they cannot be implemented, then why have them as part of instrument of instructions? So from incorrect, identify the incorrect statement. C is third. Consider the following statements regarding Controller and Auditor General of India. His office is one of the bulwarks of democratic system of government in India. His audit reports relating to the accounts of the state to the state legislature he submits to governor, president and governor, not directly to the state legislature. Governor and president in turn will cause the report to be placed before the parliament and state legislature. He holds office for a period of 6 years or up to the age of 62 years, 65 years. So what is the right choice? One only. Consider the following statements with respect to the ice sheet mass balance intercomparison exercise. Ice sheet mass balance. IMBIE is a collaboration between scientists supported by the European Space Agency and the Indian Space Research Organization. It contributes to assessment reports of the Intergovernmental Panel on Climate Change. Which of the statements are correct? B. 2 only. It contributes to the assessment of reports of the Intergovernmental Panel on Climate Change. What is this ice sheet? Ice sheet. Ice sheet mass balance intercomparison exercise. So global warming. This is focusing on global warming. Arctic melting, that's what. So that is, it is leading to Intergovernmental Panel on Climate Change. Anyway, take the choice. B. Which of the following benefits will be available to PIOs as per the provisions of the Citizenship Act of 1955? Where did we find PIOs? Article 8. Article 8 empowered the citizenship rights. They can acquire, buy property in India barring agricultural plantations, lifelong visas, exemption from appearing before the local police station every visit. What is the right choice? All. Which of the following articles are related to children? 39 has health and environment of children. 45 also has nutrition of children. 21A elementary education of children. 51A also deals with compulsory education of children under the age group of 6 to 14, all four. Which of the following statements are directives to states contained in other parts of the constitution? Other parts means not in part of directive principles. State shall make provision for just and human conditions for work and maternity relief. This is part of directive principles. State shall promote cottage industries on an individual or cooperation basis. Part of directive principles. State shall promote equal justice and to promote free legal aid. Part of just directive principles. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to the children belonging to linguistic minorities. Article 350A. So the choice is D, which is not part of the directive principles. Which of the following corporations is fully audited by the Comptroller Auditor General of India? I only thought oil and natural gas because Government of India acquires complete rights over subsoil resources. Subsoil resources. But key also talks about civil aviation, airways. So you are also taking catering to air and subsoil, because other things they are not part of this because they are part of the commercial. Life insurance, Food Corporation of India and State Bank. Oil and natural gas I know because Government of India has acquired complete rights, which was actually led to a conflict between Nagaland and Government of India. When ONGC wanted to extract oil from within Nagaland, then Nagaland the state opposed to this. It said it acquires rights. But all subsoil resources are the direct possession of Union government, including your marine. Consider the following regarding Global Peace Index. It is released by Stockholm Peace Research Institute. As per the findings of this report, the world remains considerably less peaceful now than a decade ago. India's ranking slipped in 2019 when compared to 2018. 1 year. What did happen in India to fall back in terms of ranking? India lost 4 places. So global peace. Is it the impact of Balakot, which has reduced India's status by 4 places? Because it goes against peace. It is your adventure. So as per the findings of this report, world peace. So the only thing what it is there is, it is not Stockholm but Australia. First choice is wrong. Consider the following statements about citizenship in India. An Indian citizen can voluntarily give up citizenship. The criteria for citizenship would require to be amended by a 2/3 majority. Simple majority is enough. And that is why they are reintroducing it this winter. The amended bill, Citizenship Amendment Bill 2016, which was already passed by Lok Sabha. But because new Lok Sabha is constituted, any bill which is passed by Lok Sabha shall stand lapsed. So it has to be reintroduced again. So this, I think this winter session, December, the Government of India is planning to bring the Citizenship Amendment Act 2016 to promote, help persecuted minorities to acquire citizenship. So it needs a simple majority, not a special majority. Which of the following is not considered as a public authority under the Right to Information Act? Supreme Court. Now it has said Supreme Court, even Chief Justice can come under the Right to Information Act. State Bank of India, national political parties and oil and natural gas corporation. Political parties resisted. They said they don't come under Right to Information Act. They are not part of public authority. They are not part of public authority. All other institutions fall under the definition of public authority. And who provides the definition? Chief Election Commissioner, Chief Information Commissioner. Which of the following are envisaged by the right to freedom of religion in the Constitution of India? freedom to worship in certain educational institutions, freedom of concise and free profession, freedom from payment of taxes for promotion of any religion. What is the first statement read? Freedom to worship in certain educational institutions. Veda Patashalas, Madrasas, they are all part of it. Right? So all three are part of religious freedom. Consider the following statements regarding Finance Commission. It is a constitutional body under Article 270 of the Constitution, 280. It determines the principles that should be govern the grants in aid to the states by the centre. It is constituted by the Parliament every 5th year in consultation with the President. What is the right choice here? Choose the incorrect statements. Choose the incorrect statements. Is it constituted by the President in consultation with the Parliament? No. And the first statement is also wrong. 280. 1 and 3. Right? Second one is correct. Consider the following statements about UNACTAD. Generalized system of preferences or MFN status, whatever you call, most favored nation status, or generalized system of preferences is instituted in 1971 under the aegis of UNACTAD. It is a system that is being operated exclusively by the United States. This is wrong. Even EU, European Union, has GSP, generalized system of preferences. GSP is also practiced by many other countries apart from US. So only one. Which among the following is not a prescribed way of losing citizenship in India? Renunciation, termination, deprivation are recognized. Relinquishment is not recognized. Right? Termination, deprivation. Deprivation is NRC, where the National Citizens Register deprived 20 lakh people of their citizenship rights. Termination, individual case. Renunciation, voluntarily giving up. Relinquishment is not there. Which of the following are dedicated funds established under NABARD? Rural infrastructure development, long-term irrigation facility, micro irrigation facility, micro irrigation fund, and producers organization development fund. This you should know. It is part of economics, it is part of governance, it is part of NABARD comes. Where else? Your current affairs. What is the choice? All. Which of the below statements is correct? 42nd Constitutional Amendment of 1976 added a new directive principle that requires state to protect and improve the environment and to safeguard the forests and wildlife. 97th Constitutional Amendment of 2011 added a new directive principle relating to cooperative societies. Both statements are true. 42nd included environment, 97 included cooperatives. With respect to National Organ and Tissue Transplantation Organization, consider the following. It is under the Director General of Health Services in the Union Ministry of Health and Family Welfare. It has set up in accordance with the provisions of the Drugs and Cosmetics Act, 98. Director General of Health and Family Welfare, Health Services, Health and Family Welfare. Both divisions have been set up as a mandate under the Transplantation Amendment Act. So only one is true. Which of the following language is not present in the 8th schedule? English is not part of 8th schedule. It is only official Indian languages, not European language. Not European language. Which of the following is true with respect to the Election Commission of India? The appointment of the Chief Election Commissioner and other election commissions shall be made by the Parliament. Parliament has the power. President. The conditions of service and tenure of office of the regional commissioner shall be determined by, who will determine? The president. What is the choice? B. Good. Some questions are interesting. Some led to controversies. Some test your memory. Some test your memory, but memory testing questions are hard to remember because you cannot even anticipate. You cannot even anticipate, and that is the reason why I never try to answer all 100. If you can clear 30, 60, you are through. Marks will not add. Because till now